UBC, inspiring Uganda.
Good evening and welcome to Behind the Headlines. My name is Timothy Nyangweso. Tonight we look at the proposed amendments to the Updf Act, especially looking that this is the second time it's coming. 2024, towards the tail end of the year, the minister presented a few on a 69-page to be able to make amendments. It was withdrawn, taken to the NRM caucus last Friday, deliberated, and two fundamentals were put together. One, civilians who hold arms illegally will be prosecuted. The second one is military personnel should be taken to the court-martial. The biggest question is, what is the spirit behind these amendments and to what end, especially looking at a political cycle that is kicking off? The race has begun, but the question is this more political than legal? Because if we look at the Supreme Court ruling that came and made some provisions of the sections of the Updf Act annulled, why is this coming now? Shall this face the same that the POMA Act faced, especially moving some sections from the Police Act to the POMA Act and then having them nullified? But also, Article 92 of the Constitution is the biggest question that we'll be looking at tonight. But let me get to the panel that is with me in the studio. On my immediate left, Helen Ndagire, a lawyer, also an advocate with Max, is with us this evening. Good evening, Helen.
Good evening, Timothy, and good evening to the viewers.
Making his maiden appearance on our show, Counsel George Musisi, a counsel for the National Unity Platform, a lawyer, an advocate of the High Court. He has had an interesting last 10 days. Good evening, Counsel, and it's good to have you.
Pleasure to be here, Timothy. Good evening, Timothy and the panelists. Good evening, the viewers, and I'm humbled to be here for the first time.
Thank you very much for coming. Honorable Paul Omara, representing the people of Otuke County there, is with us this evening to put perspective to some of these discussions, especially from the legislature. Good evening, and it's good to have you, Honorable.
Thank you. Good evening, Timothy and the viewers. I'm happy to be back.
He is back, and especially because we're discussing this topic, spokesperson of the National Resistance Movement Caucus, Parliamentary Caucus, but also representing the people of Kagoma North, Honorable Alex Brandon Chintu. Good evening, Honorable, and it's good to have you back.
Good evening, Timothy. I'm also privileged to be next to the next member of the Central Executive Committee of the NRM Prospective, and my Muko here.
You have had a busy 4 days since Friday.
Oh, yeah. Very interesting and busy.
Lastly but not least, Major General Felix Kulaije, Director of the Defense's Public Information Desk there. Good evening, General, and it's good to have you.
Timothy, you are having a problem with that mouthful of a title.
They should just leave us at spokesperson and then we continue from there.
It's Director Defense Public Information. Simple.
But since we still have you as a Major General, that is a good thing to go with today.
Well, good evening, viewers, and good evening, Timothy and the colleagues on the panel. It's good to be back, like Honorable Mara said. It's been some time since I was last year. I was last year as a 1-star general, now I'm here as 2-star.
Yeah. We're the ones who predicted your promotion.
Yeah, actually, at Young, the guy invited me as a Major General when I was a brigadier, and I said, "What? Have I been promoted to that?" I was on my way to Parabek. And in the evening, as I was completing the lecture I was giving in Parabek Secondary School, one of the participants addressed me as Major General as well. So when I got out, I told the brigade commander who was hosting me, that you man, in the morning somebody from UBC addressed me as Major General. This person here has called Major General. Don't be surprised if you talk to me next when I'm Major General. So I leave. But as I sat in the car, I checked my phones, and there were so many missed calls, including one from the office of the Chief of Defense Forces. So I started with that one, of course. And the young man was saying, "Congratulations, sir." I said, "Over what?" "You're now Major General." I said, "Watch out." He said, "I've just sent the message today." Now. So I meet the brigade commander in Kitgum, and I told him, "Did I tell you that you talk to me next when I'm a Major General?" So yeah, you guys predicted it. Or was it prophetic?
Whichever it is, hopefully you can also prophesy a few other things.
Yeah.
But tonight, that's our focus, and you can be part of the show. Go to our YouTube channel, drop your comment there, let us know what you think. Or our X platform, hashtag UBC Behind the Headlines. The number for your text or WhatsApp is 0709 60 92 25. Let us know what you think. But let's get into the gist of the conversation. And a few of those interesting things in that amendment are two major areas there. The civilians misusing and holding illegal arms. And the other one is soldiers, military officers that are still serving to be tasked, to be held accountable by the court-martial. Those are the areas that we will be discussing. But also, some of the amendments are to get some of the chairpersons or the representatives in the court-martial to have degrees in law. But the amendments are done and signed by the NRM caucus. Honorable Brandon, let me come to you first and foremost. What is it that you discussed? And what are the details of it? What are its ramifications to the Supreme Court ruling?
The NRM caucus we had was an extraordinary caucus, which is still mandated from the constitution of the NRM Parliamentary Caucus. But the bill we are talking about was already before a committee for amendment, the Committee of Defense and Internal Affairs, where I am also a member of that committee. So when the Supreme Court ruling came and we had to caucus, you know, the NRM members of Parliament, we are the ruling party in government, so we also form basically to bring government business on the floor of Parliament. And legislation, making laws, making sure that stability is at the forefront, it was our key major role. So the chair of the NRM caucus called us in an extraordinary caucus. But to sum it all, it was in a view of respecting and affirming the Supreme Court ruling. It's quite disturbing where people have been accusing us on social media and elsewhere. You, the NRM MPs, went to Entebbe and amended. Parliament does not sit in Entebbe or Changwanzi, but it's just a very clear action that some parties don't have a behavior of sitting and caucus and discuss, but the NRM we do. And it's also biblical that see how beautiful it is for the brothers to sit together and have a common sense of direction. So when we met, of course, we had 3 very paramount resolutions. And since the Supreme Court had already pronounced, even our committee, I remember the Major General was in our committee, we had allocated members to go for benchmark. We said, now, it's not necessary, let's follow what is there. So we requested the Attorney General, following the formal way in Parliament, how to withdraw the bill, and it was. Then we went to Changwanzi, we went to Entebbe State House to discuss and also look at it close. Not change, not fault anything, but also to respect. So resolution number 1 was that a serving officer, a military officer, that is supposed to behave in a very practical and nice way in the society. And before we go to that, we go to also a history, where we come from, and what does it mean to have the general court-martial in that, say, in a country, and the bias probably that had with the men and women that wore uniform in the previous regimes. So we resolved that, and following the guidelines, following what the Supreme Court had already pronounced, that those people will go to the institution where they belong. Because we don't know what is indiscipline in the army. Probably if you would blink at General here, if that's indiscipline. But if I am a soldier, he will take that. So he should handle that. We resolved onto that. But with a provision or an alarm of appeal. The lawyers here will tell us, I know Counsel Musisi is being all over the court-martial sometimes. I don't know how many appeals he presided or presented in the court-martial. But now there is a privilege, even to the officers within the military. And then we also looked at what the Supreme Court talked about, putting measures of appeal, that there will be a provision of appeal, so that it can be, the court martial will be subordinate to our normal civilian courts. And we also go slightly a little deeper of the qualifications the way you've talked about. And then the other resolution that actually is on the talk, because people don't look at the rest. They don't even look at the merits and the credit of this court and how it has prevailed the discipline within the forces. That if you are a civilian like Omar Paul here, representative, and is found with serious ammunitions and used them unlawfully or killed people with some witnesses, we got some evidence from people, most especially colleagues who are coming from Karamoja, from Gulu, West Nile, and those places. And I think I can remember also we had something to do with Lakwena in Busoga. So when people are giving testimony, we saw it's wise. I mean, we are also mindful of that article, the law in the Constitution that we shouldn't legislate or change the ruling. But the same court, when was giving the ruling, now you see, Timothy, if you're a legislator like me and Paul, yeah, you don't have authority to do this, but you can amend. But you can do this. So, if they give you a leeway and you want to have a proper society with discipline, because our motto is very clear for God and my country. All of us, me and Paul and my council there with perspective representing somewhere, would need a stable process. Would need a stable country where every rights are really respected. So we put that clause, a suggestion, a proposal, that at least the civilians, since Uganda is very peaceful, you don't need to have a gun. You have here Muko with security, we have police, we have everywhere. Why would you even have arms?
Honorable, let me stick with you before I get to General Kulaija. The bill that was presented by Honorable Minister of Defense, Jacob Oboth, had two elements that were specific. One, bringing the SFC into the service. Two, the Deputy Chief of Defense Forces was also going to be the Inspector General of Defense Forces. This one talks about taking the court martial back. Really, was this a necessary law for everything that Uganda needs to be deliberated by you on Friday?
Timothy, Parliament has its legislative agenda and program. And if you ever get tempted to be an MP, you will not come out with issues that this is this is the specific, that it should be on the order paper. This is my priority. Me and Omara tomorrow, we may not know, probably now they have posted, but we may not contribute to know what will happen on the order paper. So since it was the bill that was already and it was supposed to come to Parliament, so as members of the NRM, we had to take it as a priority.
You withdrew the bill. You brought it back.
We have not yet brought it back, but the bill is withdrawn.
337 people have discussed this bill. Of the 529 that are in Parliament, really, the numbers speak for themselves.
Parliament does not sit in Entebbe. Parliament sits close to you here. So the 300 and something members of the NRM.
Signed off this amendment?
We didn't.
Let's get to the meat of this. Why do you want civilians to go to the court martial?
There is a history. When I was growing up here, I used to know, actually used to hate Swahili. I've just started appreciating it. Because Swahili was used by men and women on uniform, routing, doing all those sorts of things that are very inhuman. So, you would look at someone in a uniform, you already judge. Now, we are talking about discipline. We are talking about some people also camouflage that can do the same uniforms and some attires, and sometimes they develop ideas. Now, if you're a civilian, and you know that the president takes an oath to protect you and the institution take care of you, why would you want to create instability? And I don't want us to start assuming that we should make a law, or why should we in assumption of assuming, though there would be some people who would commit crime. We shouldn't think like that. So why would civilians be subjected? We have ways of a civilian to acquire a firearm licensed. But we are talking about these people that are having, you know what we are talking about, unless you don't live in the country. But if you go around and do your benchmark, this justification, you'll get it. So why it's quite large, that will need maybe a very big, extensive. But since we have here a spokesperson of the army, he may know and actually extensively tell you the beauty and how useful it will be for this country.
Okay, thank you. General Kulaije, what do you make of these proposals? You sitting in both the docket, having been a legislator, but now also the spokesperson of the army, is this something that you need as the army?
Yes. And before I make my submission, I better help my Muko here with your last question, with an illustration. Assuming I commit a crime when I'm with Brandon. He is a civilian, right? When you arrest us, are you going to take Brandon in the civilian court and you take him in the court martial? What happens then to the evidence? Are you seeing the point?
Mm-hmm.
So if you commit a crime with a combatant or an officer, then you ought to be charged together in the court martial. If he assists me to commit a crime, then he has qualified himself to join him in the court martial. That's the amendment that is being brought on board. 3, you are armed as a civilian, right? When you commit aggravated robbery, first of all, you acquire the arm illegally. Then you commit a crime with the same gun, you qualify yourself for the court martial. Those are the areas we want to relieve you, you in the civilian courts, to deal with, because these are a monopoly over the military. Now, to my submission. The civilians who are society, right, live in an area called the territory. And that territory is supposed to be governed by a governor, who is the government. These governed cede their authority to a particular entity, in this case, government. The governor, therefore, has a responsibility to protect the governed, defend their territory from an intruder. Okay? And therefore, they cede the authority to raise an army to the governor. It is the duty of the governor, therefore, to ensure that they are not only protected from an external intruder, but they are also protected from errant members of the entities that they have created as a governor, or he has created as a governor. So when the government raises an army to protect the territory, which is occupied by the governed, in this particular case, a territory called Uganda, the governor must, as of necessity, protect these citizens. But 2, the governor must remain with the monopoly over the means of violence. The day the governor loses that monopoly, you have a collapsed state or a failed state. Now, failure of the state is an indictment to the governor. And in this case, it is double jeopardy. He has lost authority, but he has also lost the trust and confidence of the governed that they had given to him to protect them. Hence the emergence of warlords. And this country has been there before. 1985, this road here, 9/11, as a matter of entitlement, there would be a dead body every morning. There is a BBC report that Uganda is now a failed state. This was a correspondent, and he was reporting along here. This was January 86. So, like I think they said, knowing our history. Is that how you started in your caucus? Yes, in the preamble. Knowing our history, and I want to assure you, Timothy, we have forgotten, some of us. The young people don't know that we have had this history. And I want to assure you, there is a scar. In the event of an accident, that scar will become a wound automatically, if you like it or not. Number 4, you live in a region that has 3 conflict zones or systems. The Great Lakes conflict system, the Sudan conflict system, and the Horn of Africa conflict system. These conflict systems have small arms proliferating into the country. Therefore, non-authorized persons can easily access firearms and ammunition. Knowing our encumbrances within the traditional judicial system, many of which the councils know better than I do, backlog, like you have cases of people who have been on remand for 9 years. If you are dealing with matters of violence, you cannot afford to wait for 9 years for judgment.
But how is the proposed amendment supposed to stop the weapons from coming into the country? How is that supposed to stop?
What's the purpose of punishment? Purpose of punishment is one is deterrence. So if Kuraji is sentenced to 10 years imprisonment, another person who may have wanted to assist Kuraji commit a crime will think twice. It's not about enjoying the neckties in the court martial. No. It's protecting you from deteriorating to what we have seen it before.
And we're going to
knowing our history.
General, my last question before I come to Helen. The General Court Martial, with these proposals, how will it pass the test of fairness? How will it pass the test of impartiality? How will it pass the test of independence? But most of all, of competence?
First of all, I will start with the last. The Supreme Court recommended the presiding person of the court to be a person that qualifies to be a judge of the High Court. In the amendments there, I'm sure you have seen it, honorable members. That's number 1. Number 2, this very court you are talking about has acquitted some individuals. It didn't get orders to take them back. We have a history with that court. 3, you know, the English have a saying that if it's not broken, why fix it? This court has served us for 38 years. For the UPDF, even more, because we had this in the bush as well, with the code of conduct. And I want to assure you, until 1999, when you people stopped us from handing out the death sentence, cases of soldiers murdering civilians, soldiers raping women, defilement had gone to the past. Because for us, it was simple. You rape, you die. You kill a person, you die. But human rights activists say, you know, you are violating the rights of the accused. What about the right of the one who has been killed? So for us, the Hammurabian way was the way that enforced discipline in NRA and endeared us to the public. Just in recent times, how many soldiers have killed civilians? One killed people from Lango, in Kitgum, the other in Bosoga. 5 people. Because after all, today, the man will live. You sentence him to 40 years, if he's 20-something, at 60-something, he'll be free.
But isn't this duplication, General? Because there's already the penal code to handle such cases. Then why have the General Court Martial handle the same cases?
Have you heard of the word complementarity?
The industrial court does not get involved in matters that are criminal. When you're talking about complements, you complement by making the land better.
Yes.
Really, are you making the civilians' lives,
when,
the military
when
people's
we,
lives
we
better?
leave the civilian courts the burden of having to try even these people who have decided to turn themselves into armed human beings, we are allowing the courts to concentrate on the other cases.
Honorable Mara, you have a comment before I get to Helen here.
Yeah, thanks. Timothy and viewers, after listening to our two panelists who have already spoken, the issue at stake is actually, which is being discussed, is about our constitutional democracy and governance, and on matters that relates to national security. Now, we wouldn't be doing justice to this conversation if we can't look back into our history, and I want to delve into it quickly. In 1986, NRA, NRM took over state power in Uganda. And what was established as a tool, as an enabling law of the state was Legal Notice Number 1 of 1986.
Yeah.
And that Legal Notice Number 1 of 1986 had very many components. NRC, which was a modicum of parliament, was there, National Resistance Council. And by the way, the president was the chairman of that council. Then the code of conduct of the NRA that was in the bush was put into that legal document. Now, that served the country for 4 years. And soon Ugandans realized that they needed to create a new constitution. An Odoke's commission was appointed. They went all over the country and came up with a document. And soon later, the people of Uganda decided that we don't have to use the NRC to basically debate this new constitution. So we brought in the Constituent Assembly delegates that debated this thing. Odoke's document was basically used as a reference point in the conversation. Now, what we need to understand about our constitutional democracy is that if you look at 1962 Constitution, that was more or less a kind of a federal Republican constitution, which became chaotic by 1967, and 66 crisis, and then the pigeonhole constitution in 1967. Then later on, we had the military coup in 1971. Fast forward 79, there was a war in Uganda. 1980 elections. 85, there was another military coup. So the conversation was around what kind of constitution do we need to really make sure that Uganda is on a platform to democracy, and there are different center of powers that can learn to work together. And so that's why in the preamble of the 1995 Constitution, it talks about, given our history, what kind of constitution must we have? So if you look at our Constitution, it created 3 arms of government: the Parliament, the Executive, and Judiciary. Each one of them has a distinct role that they play. Parliament has the right of appropriation, the right of legislation. The presidency is the commander-in-chief of the armed forces. The judiciary has been given powers of interpreting the laws, any laws that we make, and also has been given powers to adjudicate over matters which is civil and criminal. But how do I call it, the central pillar that pulls all these 3 arms of government together is the presidency. As the Major General said, now the president has a responsibility of making sure that Uganda is protected from any kind of external aggression, and also any kind of internal instability, some guys who can pick guns and create problems. Now, remember that Legal Notice Number 1 of 1986 died in 1995.
Yeah.
There was a compromise between the NRA then and the public now. You see, when you fight a war, you have to give up to a civilian governance. So in that constitution, Ugandans agreed that the NRA should be in parliament, 10 of them, and we still have them up to today. UPDF, we have 10 representatives in the parliament. Now, the code of conduct that created discipline in NRA and later on UPDF was now encompassed in another legal document created by Parliament, which is the UPDF Act. Now, of course, during the creation of UPDF Act, the legislators didn't look at the import of that on the Constitution. Remember, the lawyers are here. They said if any law is not in line with the Constitution, is null and void. So when this matter was taken to court, the court has made a ruling. And I want you to flash back. One of the issues that the 1995 Constitution fought, and which the framers of the Constitution looked at, was that in the past there were coups every other day. Army commander can wake up and he's not happy with the president, he overthrows. So that is why in Chapter 12 of our Constitution, and specifically Article 208, subsection 2, it talks about that the UPDF will be basically a disciplined force, non-sectarian, and will represent the national character, and most importantly, will be subordinate to civilian authority. And that civilian authority, under the Constitution, by the way, civilian authority is the Parliament, is the judiciary, and is the executive. That is why when the court, the Supreme Court, came up with a ruling, the aggregator of the government, as we see it, the aggregator of that government of Uganda is the presidency, and the commander-in-chief. So I want to thank the UPDF because they, following the Constitution, they said we are going to follow the law. And then the UPDF Act should be amended actually to reflect the command of the Supreme Court. But we will go into the details which have been mentioned, what has been proposed, and I want to go over it quickly.
Let me come to that one,
yes.
Honorable, let me come to that one.
Okay.
Helen, let me come to you. When you hear these proposals, especially the 69 pages that were presented by the minister, but also the proposals that were in the caucus, are they in line or out of line of the Supreme Court ruling?
Thank you, Timothy. I would say that given the discussion we are having here, the proposals have taken certain aspects of the judgment and tried to implement what the court's decision is. But however, there's a fear that whatever proposals have come out of this meeting are trying to circumvent the crux of that decision, being that can civilians be tried in military courts? I would start by saying that the amendment in itself to the UPDF Act, because I've had the opportunity of reading the bill before, even if it was withdrawn, it is not bad in itself, because when you look at it, there are two aspects to it. The pros of it that no one is or is not publicized is that it comes in and looks at the welfare of the military servicemen. It also comes in and looks at providing for their pensions, putting up a medical board. Yes. So it's also looking at other aspects that are administrative and also promoting the welfare of the people that are serving in the UPDF. However, on the other side, we have the big question as to whether the amendment to include the trial of civilians in military courts will, can suffice given what the proposals are. And in my opinion, I would start by saying that Major General Kulaije has made a statement that what would happen in a scenario where we have a civilian aid or abet a military man, or yes, a military man, I use that statement broadly, not just because I understand there are women in the forces, and and he pointed out a question of evidence if we are to separate the two. For example, we have a civilian and then we have the military person, and he said that what will happen to the evidence, but the answer to that question is that whereas we have concerns about the security of the country, we also have to go back to the grassroots and understand that jurisdiction under the law is not a question of evidence, it is a question of law. So if a certain body or a certain tribunal or a certain court is not vested with jurisdiction, regardless of what action it takes, that act would still be illegal. So when you're looking at the question of jurisdiction, it's not a question of evidence, it is a question of law. And you've made a correct assessment as to the fact that we already have laws in place that provide for the trial of civilians. For example, we have the Penal Code Act. They have talked about the Firearms Act, which regulates the possession, sale, distribution of.
And licensing.
Yes, and licensing of firearms. So if a civilian is caught or is found in possession of illegal ammunition, that act can be called into question. There are provisions under the act that provide for punishment for such actions. Then also on the question of the fact that this person is threatening the security of the country, we have provisions under the Penal Code Act itself, for example, that provide for treason. So these various laws or enactments still cater for the civilian population. So there's also a question on aiding and abetting a military personnel. And the answer to that is that when you look at the Penal Code Act, specifically under section 19 and 20, there are provisions as to joint offenders as well as those that principal offenders, aiding and abetting. Where someone, if something takes the character that we act in conjunction with each other, in that we acted at the same time with the same mind and our intention was to commit a criminal act. In that case, our criminal liability is held together. What they find you guilty of, I will be guilty of. On the other hand, where someone aids or abets, their criminal liability can be individual to them. So in this sense, where we have someone or the military person go to the court martials, they can be found guilty there. And at the same time, the person aiding or abetting can be taken to the civil courts and they would still be found guilty of the same, given that principle of aiding and abetting, the fact that it can give rise to independent criminal responsibility. The only question that can come in is a question of judicial economy, in that does our judicial system have the sufficient resources to cater for such separate proceedings? And the quick question to that is, rather the quick answer to that is that it now tasks the people that are in charge of the administrative running of the courts to make sure that there's a system in place where we can see that being done in a fair and speedy manner, taking into account the fact that one of the main or the major human rights in these proceedings is the right to a fair hearing, or a fair hearing, which includes a right to a speedy trial. So in this case, I don't see why we still avoid the big question as to, since the court has already made a pronouncement on that, it has told us that civilians cannot be tried in military courts. So whatever amendment we propose should take that into consideration. I understand the security concerns that are there, but we have a system in place where both parties can still be tried in the courts that have the proper jurisdiction to do that. So in my opinion, the proposals in themselves are taking into account the decision, but there's still a lot to be done to see that the full effect of that decision is implemented and enforced.
When we come to Article 28 and 44, that talk about, you know, impartiality, independence, right to a fair hearing, can the court-martial pass that test, both for military serving officers and civilians?
Timothy, I think as it is, since we haven't had an amendment to the UPDF Act, we know that the decision has said that they do not pass the test. For starters, there are issues as to impartiality. And in that decision, the court went ahead to look at the oath of allegiance that is taken by servicemen, and vis-a-vis the oath of allegiance that is taken by the civil courts. In that, where serviceman is pledging allegiance to the president, the judicial officers are pledging allegiance to the constitution. So there was a question of who are you answerable to? And
Yes.
yes,
Actually, we pledge allegiance to three:
yes, I understand.
the president, the constitution,
The
the country.
constitution and the country, yes.
So we are more loyal than any other institution of government
Yes.
to both the country and the constitution.
That is, well, but
So
it was a
we
concern.
are bound 3 times.
Yes. But the concern is if part of your allegiance, and we understand that he's the person who, or he's the, yes, he's the commander-in-chief of the armed forces. But there's a question of if you owe allegiance to someone or you're answerable to a certain person in your capacity of imparting justice or administering justice to the people, are you going to be impartial? That is the bigger question. I am not making an insinuation that by owing allegiance to the president, you're immediately taken to not be impartial, but there were concerns on that. And then there was also a concern as to qualifications of the people who sit on the court martials. And I think that is something that they have ably addressed in the proposed amendment. So it's good to see that there's progression into adopting the decision in itself, but I think we need to also focus on the crux of the conversation, being that the court has made it clear that civilians cannot be tried in military courts.
And you've mentioned something that has caught me, especially on the part of the appointment is basically from the commander-in-chief. On the other hand, the Judicial
No,
Service
sir.
Commission.
No, sir. They are recommended
By?
the high command or the leadership of the military.
So which is not the Judicial Commission?
No.
Which is not the Judicial Commission. Let me come to you, Council Musisi.
Who appoints the judges?
They're recommended, right?
Yes.
But who appoints them?
On the recommendation
So
of
the
the judicial-
appointment of both sides is by the same authority, right?
let me come to Council, even as you respond to him. The spirit behind these amendments, these proposals, what do you make of it, especially in this season?
Of course, they are mixing up issues. Honorable Brandon's group. One, indeed, the Supreme Court made recommendations for amendment. And if you are in line with what the Supreme Court recommended, then if you're making arrangements in that line, then you are not against Article 92. Article 92 forbids Parliament from legislating something which overturns a decision of court. Now, what was the decision of court in Kawazuguruka? First of all, in the Constitutional Court, the gist of the matter was not whether military courts are there lawfully or not. No. Court agreed, and we all agree, that they are there lawfully. The question was, who should they try and what offenses? In the Constitutional Court said they shouldn't try civilians. In fact, the lead judgment of Justice Kakuru even addressed, Timothy, you're asking something, Helen, that the issue of fair hearing. Justice Kakuru, I remember asking that, how about soldiers, like General Kulaiji, don't they deserve a hearing? And he said, well, they do, but by being soldiers, they have ceded some of their rights too. So in other words, the gist of the constitutional decision was civilians shouldn't be tried in the court martial. The Attorney General appealed. The gist and the spirit of the appeal, of course the appeal was dismissed, meaning they upheld the lower court decision that civilians shouldn't be tried in the court martial. Now, if you're bringing any amendment that is bringing the trial of civilians in the court martial, it's certainly going against Article 92, certainly. Now, why I'm saying that they're mixing up issues, Honorable Brandon tells you that no, we are amending because that's what the Supreme Court said. The Supreme Court's amendments were not general, they were specific. They talked about the composition of the court, the competence of the court, and that's why I said that General College is diverting you. The appointment of judges follows a specific route. For instance, people apply. If we all have the minimum requirements here, we apply to a different body. The different body takes us through interviews. That body recommends to the president. Then after the president making the appointments, they go to another body, which is parliament, a vetting committee. That is a tripartite process, unlike the other one, where, well, of course he's telling us that the high command applies, but we all know. But either way, let us talk about disappointment. Today the president cannot wake up.
Would you mind telling us, Council, what you all know?
General College knows
No,
more than anyone
since
else.
you all know it's not confidential.
Let's talk about how they can be removed. The president cannot wake up today and say, Justice so and so should be sacked. No, there is also another process. In fact, that process of removal of judges in Uganda today has never even been full, under our 95 constitution, has never been fully, because I remember Justice Okumuwengi, there was a committee appointed and then he resigned before. Justice Chondri Singh, now Justice Kisache, there was a recommendation of a committee. It's a hard task. However, if you're the chairman, Court Marshal, General Kweje today, the commander-in-chief can say, stop, and tomorrow another person will be there. It doesn't have to go through parliament, you'll be arbitrating over matters. So the recommendations of the Supreme Court were specific that do these things, because even soldiers, leave alone civilians, deserve a fair hearing. General Kweje today, if he was to face the court martial, and God forbid, just imagine if the commander-in-chief says very strong words against General Kweje, that this one is a criminal, should be tried. If he went before the court martial, there are high chances that you won't get a fair hearing, because...
Are there precedences in that matter?
Of which matter?
Of the president giving orders to the court martial?
Of course. Of course.
Are there precedences?
So many.
Please cite them.
Let me cite them. In fact, it even goes against the... remember when General Kaihura and that group were tried?
Yes.
And the prosecution, when they arrested, I think it was 2017, said that we are ready to start trial. We know that 5 years later, trial hadn't started. So even this fallacy that, the court martial's first trial hadn't started. They were just lucky that some of them were out on bail. If they were in custody, there are people in Chitaja today who were remanded by the court martial 7 years ago. They're in Chitaja and the trial hasn't started. I have represented clients who were arrested in 2020 and 2021. Their trial hasn't even seen, you don't even know where it's going. You don't know whether it's ending in the next 1 year. You don't know. I'm an example. So his whole fallacy that it's faster. But before you digress, the issue of amendments, and you asked me, Timothy, the spirit, is there a need for amendment? Yes. A court martial is there lawfully? Yes. The question is, what is the extent of the amendment? So the spirit of bringing in the smuggling in of this issue of civilians, it's certainly going against the judgment. Secondly, why is this whole hullabaloo about the court martial? General Kweje say that, the governor must protect the governed, state must maintain a monopoly of violence. All that is correct. However, all that should be done under our constitutional dispensation. 30 years ago, Ugandans came and said, we are going to be governed by this sovereign. The constitution is now the sovereign,
yes,
not the emperor. So when you put the law the sovereign, that means that everything that must be done should be in accordance with the constitution. That's why we have the constitutional court to discuss, is this act of the executive in line with this? Is this law of parliament in line with this? So because we put law on top of everything else. So if whatever action of the governor should be in line with now our sovereign, which is the law.
May I inquire?
Yeah, sure.
Who protects the sovereign?
Of course, who protects the sovereign? It's several institutions. Parliament protects, the courts protect.
May I inform you, sir?
Yes.
The Nigerian constitution has safeguards. One of them says, anybody who attempts to overthrow this constitution shall be punished by death. How many times has it been overthrown?
Okay, it seems Mr. General Kweje's information is meant to digress me. I'm not allowing any more information from you. Let me talk about the Ugandan constitution, which I know very well. Who protects the constitution of Uganda are the institutions it has created. It's created the judicial, it protects the constitution. It creates parliament, all the other institutions. But importantly, Timothy, the spirit is meant to ensure that civilians are before the court martial by hook or crook. Now, when they're talking about civilian trials, they tend to talk about the extreme. They say if people are caught with guns, if people are First of all, even the example he cited, that supposing two people co-offenders, one is a civilian, another soldier, our courts, for instance, the High Court, is given unlimited jurisdiction to try any offense under the sun. For crying out loud, people who bombed people in Lugogo were tried by the High Courts. Why didn't they say that these terrorists don't deserve to be? They used bombs. They were even. We have crimes committed across borders. They have been tried by. So this business of saying that no, because that is a fallacy they create. The army is best suited to handle this if you are caught with a gun. Then even doctors will say, if a doctor is caught in malpractice, you give him to us as the medical council. We are best suited to handle. Then even reverends will say, most importantly, yeah, because we've had cases in church where Christians have sued the archbishop. They have gone to these courts. We've had cases of malpractice, of medical malpractice. The issue I'm trying to bring is that the recognition in this Kabazi was that the court-martial is more like a tribunal which is meant to enforce discipline. And everywhere around the world, court-martials are used more for the military. Court-martials are not, what has made the court-martial very prominent, even amongst the Ghana citizenry, is the prominent trial of civilians, increasingly, which is actually not, this argument that no, you bring them to us because you are best suited, doesn't augur well, because like we've said, one, even the fact that there was no right of appeal to these other courts, because if you look at Kenya, for instance, which has a younger constitution than Uganda, court-martials try yes soldiers, but even soldiers have a right of appeal in these ordinary courts. So that also the Supreme Court talked about, and that's a full amendment. But we've seen, you carry out an examination of the civilians who have been tried in the court-martial. I've represented over 500 civilians in the court-martial in the last 5 years. I don't know of any who was found with any AK-47. Neither is any charged with having been found with an AK-47. It's T-shirts, water bottles, 2 bullets, peep.
Water bottles or petrol bombs?
No water bottles. There's one called, it's called Martin Mwanga.
Don't bring drama here.
It's called Martin
Don't bring drama here.
Just take note of it, you'll come to it.
Yes. There's a gentleman called Martin Mwanga. He was arrested last year on January 26th. He's a councillor in Chengera. They said, you know, the Supreme Court annulled a provision in the Updf Act where they said that being found with equipment, which are a monopoly of the armed forces, because they said it's general, it's vague. Many of the civilians before the court-martial were being tried under that section, because the question was, which materials are a monopoly? A criminal offense should be defined such that I know that this kind of behavior is prohibited. But the increasing usage of the court-martial to fight increasingly political battles is what has brought it in disrepute with the public. And I imagine that the court-martial has achieved some other things. And I imagine that even the recommendations of the Supreme Court can only make it better in terms of, but the issue of, the sticky issue is the trial of civilians.
Thank you very much. Lastly, Honorable Mara, yes, what is the fate of constitutionalism in this country? Because if these proposals go through, there are some laws that cover some areas of this UPDF Act. Yeah. There is the Firearms Act that is there, that talks about regulation, that talks about imprisonment, that if you display an arm, it's 1 year. If you negligently shoot, it's 5. There is already, what does this mean for constitutionalism?
Now, there are some of the concerns in the public. Some of the concerns in the public is that the amendment is kind of an executive or a military overreach onto the roles of the judiciary. Now, I think the able lawyers talked about quite a couple of things, but the amendment which is coming is basically, in the main, a recommendation of the Supreme Court. Now, we all agree that even the soldiers themselves deserve justice. Mm. And one of the reasons why the Supreme Court annulled the court-martial itself now is because of how it is constituted, its independence, the tenure, and many other things. So in the amendments, the Land Attorney General has brought in recommendations, and he's worked very closely with the member of UPDF. And within the UPDF, there are also good lawyers there. So they've come with recommendations that how do you create, first of all, a discipline within a unit, more administrative discipline, and then also now you're creating the court martial. And from the lower levels to the court martial, they have had to make sure that those guys who will be there are qualified, they are lawyers, and so forth, and the terms and references. In fact, one of the recommendations is that the members of Judicial Service Commission must be what? Involved. So they want to cure what was basically found out by the Supreme Court to be illegal. So I think with that one, there is no contestation. Councils, you believe. There is no contestation in terms of making sure that the structure of the court martial as established by the law is actually more democratic and more independent and can provide justice. I think the second one, which is more, how do I call it, contentious, is basically the trial of civilian in a military court. And basically we are looking at Article 92 of the Constitution, which says Parliament cannot go and do a retrospective legislation against the ruling of the court and between the parties. Now, that is going to be something that we raised, actually, is something that we raised during the caucus meeting with the Attorney General. Said, but there is this provision of the Constitution which debars us from doing any kind of retrospective legislation. And the Attorney General said, no, it will not offend Article 92. But then he also says that some of the recommendations came from the Supreme Court itself, where they're saying, if you want to have their extraneous, exceptional circumstances where a civilian can be tried in a military court, you need to have clarity. Now, so that is where the contention is. So you have Chapter 8, which establishes the judiciary, and which, especially Article 126, which says that the judiciary can legislate over matters which are civil and criminal. And also at this particular angle, we are giving the court martial the powers to try civilians in a military court. Now, here is where the problem, where it's something that this conversation, we must continue to have it. As General said, you see, the presidency, you have a responsibility to secure the country and making sure that people's lives, people's properties are protected. And also at the same time, you need to create harmony between different arms of government and making sure that it is not, there is harmony, there is no conflict. And so that responsibility, that's why the president recommended and said, okay, we are living in an environment where we are almost an island of peace in a sea of war. If you look around us, there is gun proliferation. There are civilians involved in carrying these guns. So the question we are asking is, if you are a civilian and you have acquired a gun illegally, you have gone and shot somebody, and as my sister said correctly, that is provided already in the penal code. I think why this thing has become very...
I'm going to jump in there. The president, I think, a few years ago when there was a lot of gun violence,
yes,
there was that fingerprinting, yes, of guns.
Yes.
So really, isn't this a whole contradiction to cure a problem that...
So that was done. So what is it that we want to cure? Why is it that we feel we should take civilians to a military court, especially those who have acquired guns illegally and violently used it and so forth? I think, and we need to be honest among ourselves and be open to each other. If you look at some of in our judicial processes, sometimes it takes too long. There are very many case backlogs. In some cases, some judicial officers are corrupt. It's sometimes difficult to get justice even in the process. We are not saying in the military there is it is the same thing. So the country is actually now thinking, where do we go? And so the solution.
Honorable, is that justification for
No, I'm not saying.
construction of parallel courts?
No. I'm not saying that is. I'm saying that's not the justification. It is the concerns that the people have in the public. So where you are dealing with national strategic security, if you have gun proliferations and you want now to deal with them frontally, how do you go about it? And that is the question we are asking. And that is still a recommendation which has to come before Parliament, that if you, in the recommendation which we have seen, if, Timothy, you acquired a gun legally, and somebody gets your gun and uses it and commits crime, then you cannot be taken to a military court. You can go to a civilian court. That's part of the recommendation. One of the recommendations is that if you acquire guns illegally and you use it to disturb people, and the case which was given was Karashunas, the Karashunas in Karamoja, and I'm told about 5,000 are in jail, and they all went through the military court. Yeah, and they said, if you are going to put 5,000 Karashunas through our judicial court system, how long is it was it going to take us? So there is this conflict which we must address, and I am mindful of Article 92. If Article 92 of the Constitution, which stops Parliament from doing retrospective legislation, is cast in stone, then maybe even our little efforts in making these amendments, if somebody walks to court tomorrow, to make a walk to court tomorrow, the same provision which we will make in the UPDF Act might be annulled by the same court. So it is a challenge. We must have that conversation and say, do we have a window of strengthening the UPDF Act in such a way that it provides for our national security, it provides deterrence for those who might want to misuse the gun to destabilize the country. So that is where the conversation is.
It almost sounds like cherry picking on who goes and who doesn't go of a civilian.
Yeah.
I'm itching to ask this question. My daughter there kept on referring to speedy trial. Okay? In UK, last month, when there were these riots after the killing of a black boy, some people were tried in 3 days, sentenced to 30, 40 years imprisonment. That's a speedy trial. Have we witnessed such in Uganda?
So is that justification for the proposals?
Of course it is.
For a speedy trial?
Yes.
Does that guarantee justice?
It does.
General.
I've just given you a case. Precedents in UK.
Did happen here. Does it
Precedents
guarantee
in
justice?
UK, 3 days, people have been 47 years. In 3 days.
Okay.
So there is a precedent, Timothy.
I'm itching to answer.
let me allow Council Msisi to respond so that I can read some messages. Council.
Well, whereas I'm not alive to the particular case that Kano is, Geno, I apologize, the Major Geno Klaje is talking about, the institutions
Can
of
I
the
lend your
UK
phone and your Google?
No, what I'm saying, the institutions of the UK are very much different from the institutions of Uganda. We very much know the hold the commander-in-chief in Uganda has over the army and the attendant institutions, to the extent that his word, General College has just said that their allegiance is large to the president. And of course, to others.
Unlike you people who are to one.
Actually, if you pay the allegiance to the Constitution, by default, you'd have paid allegiance to all the others.
No.
Unless you think the president can be outside.
For clarity, for us we must be clear.
So,
and
the whole may not...
you see, I did teach you the political economy of politics, young man.
General, allow me that we take a break and come back to you. Let me read some messages that have come through. To let the court-martial continue trying armed civilians, because once you are armed, you cease to be a civilian. This is Tugume Richard from Hoima, okay? Interesting comment there. Someone else leaves no name and says, this Kiza Besije case is a serious governance problem. We should pray that he's innocent. There is no business of saying free Besije. That's nonsense. There is how people should be charged in a case of this magnitude and should not be freed. The same judiciary system that praises to be taking cases in the military court should be able to provide civilian justice or on the civilian pressure, something that is unconstitutional in the name of freedom, okay? Good evening, Timothy, thank you for the show. Afande Kulaije seems not aware of the challenges of the military court, just like civilian courts. Case backlog is not an example to court-martial. There are suspects who were remanded by the court-martial for 4 years and have not been tried since 2021. This is Silva in Mutukula, okay? I salute the General for his submissions. Nothing is wrong with the amendments, but Parliament should go ahead and align the Supreme Court recommendations. Secondly, the opposition parties in Parliament should wake up and do what is right and stop making noise. Wilfred from Pakwach, okay? Lastly but not least, good evening, Timothy. Thank you for the show. Why was Jamil Mukulu tried in a civilian court? Does it mean that civilian courts have no capacity to handle criminal cases by the use of guns? Can Honorable Brandon explain the court-martial on more of its competences than the civilian courts? Why were those who killed people in the streets of Kampala around 2021 not arrested and taken to the court-martial? This is Stephen Egwang. Okay, finally, so that we take a break. General Kulaije should also tell us how many cases of guns they have had in the court-martial. We still have a list of guns here, but they keep a blind eye just because they are not threatening the rule or the chair. Okay, the rule and the chair. We'll leave that at that. Let's take a quick break. When we come back, we'll get into the intricacies of the recommendations, but also the proposals there.
Osmosis again. Osmosis tried to pay. Money wasn't enough. He checked every pocket. Money wasn't enough. Osi, we're sorting it. With the Momo, we're sorting it. Osmosis checked again. Money still not enough. He looked everywhere. Hey, but what is going on? Osi, we're sorting it. With the Momo, we're sorting it.
When your money is not enough, we're sorting it with MTN Momo. Use the Momo app or dial *165*5# to add call with Momo Advance and pay bills, send money or buy bundles.
This PDM is to get all of you out of poverty. That's why we said 100 million per parish per year.
The parish development model is designed to eradicate poverty by providing the support necessary for financial independence.
We have seen how 1 million, how much 1 million can do. The whole of Uganda is very rich. So what you call poverty is actually ignorance. You need everybody to come up.
Let us all take advantage of the conducive prevailing atmosphere of political stability, peace and security to ensure that all our people come out of poverty.
And I've told the banks to stop deducting from the 1 million. You must get the 1 million full. The government is the one which will pay the bank charges.
Now the number of stools in this Matoke enterprise are 1,000. They are on 1 acre. And we harvest 17 bunches every day. The money that we get from this Matoke, after selling each bunch at 15,000 shillings, for the whole year, we get 91.9 million shillings. So I want to encourage all the people of Teso also to change the mindset and adopt to new crops which were not traditionally grown here.
We emphasize 2 words, wealth and jobs. This PDM is to get all of you out of poverty.
This message is brought to you by the Ministry of ICT and National Guidance.
Welcome back from that quick commercial break here on Behind the Headlines, and we're discussing everything the proposals to the UPDF Act that were recommended by the NRM caucus that sat on Friday. In the studio, I have Helen Ndagire, a lawyer. I have Musisi George, who is also a lawyer. I have Honorable Paul Omara. I have Honorable Alex Brandon Chintu, and I have General Kulaije. And we're discussing that. You can be part of the show. Let us know what you think. Just send us your message there. But let me read two messages so that I get to General. He had a comment to make, as both the General and Council Musisi were itching. Before we took a break, let's see if their itch was handled. Timothy, good evening. My question goes to Afande. Why have they taken long to take the seed? I don't think I'm going to read that one. Let me leave it for later. First of all, who is the head of the court-martial? The president or the CDF? All the judges in the court-martial take orders from the commander-in-chief and the CDF. These people do not have any legal background. Then we find the complainants at the same time as the judge, which is a conflict of interest. Another question is, what about the business where you find that you have been framed by someone by planting a gun in order to frame you or her? How will this be handled? I do not see any fairness in these kinds of situations. This goes to General Kulaije there. One that comes in from Honorable Brandon and Honorable Mara's colleague. This is a Member of Parliament from Kabera Maido. He says, in the civilian courts, the trials start with arrest, investigations, submission by police, files for perusing by the DPP as established if there is a case for trial. What happens in a case of a court-martial? Who does the arrest, investigation, files, recommendations, and who does the role of the DPP? This is Eresu John from Kabera Maido. Honorable, thank you very much for your message. General, let me come to you. You had a comment before I put a question to you.
Actually, I want to start with what many of you are talking of. The president is the appointing officer. The president is the court-martial independent of the president. As if the president is the complainant in the court-martial.
Many times.
No, not at all. So let this misnomer and deliberate misinformation be corrected.
The complainant.
He is not the complainant. And therefore, the fact that he has the authority to appoint does not interfere in the running of the general court-martial, because he has no personal interest in the management and running of the court-martial, but rather the official interest of ensuring the stability of the country. Number two, you see, these comments about human rights and freedoms and what have you are all very good values, and we all want to enjoy them under normal circumstances. I'm glad Honorable Mara talked about an island of peace in a sea of conflicts. And that brings me to the very question you asked about the branding of the guns. Okay? If you are in a sea of conflict, arms proliferation is automatic. Whether you have branded your official guns or not, there will be guns in wrong hands. Okay? And like the case he gave you of the 5,000 Karachunas, if you had brought them in the traditional judicial system, how long would you have taken to secure convictions? 3, any society that forgets its history gets lost. And that's why even the preamble of the Constitution, remembering our history. In the amendments they are bringing, knowing our history. It's very critical that when you are legislating, when you are giving out, you are formulating policy, be mindful of your history.
Yeah.
So that you avoid a repeat of the past mistakes. Someone stated it's not history that repeats itself, it's people that repeat the same mistakes that have happened in the past.
General,
So,
there was a question about Jamil Mukulu, but also the second...
I'm coming to it.
The second question I want to put to you is the tenure. Council Musisi spoke about, you know, how the judicial officers get to where they are, but also how it's rigorous to get them out. In the court martial, the chairperson is given 1 year. This amendment says to give them 3 years, but also doesn't guarantee their tenure of work. If a role or a case is ongoing for more, like the ones Council Musisi is handling from 2021 to now, and 3 years elapse, and we get a new chairman, doesn't that become a contradiction, especially in such an amendment?
A court does not rely on one individual, number one. Number two, the system of the court martial uses what you'd call the system of assessors. That panel is never overhauled completely. And that panel includes, one, you have a prosecutor who is a qualified lawyer. You're asking who would be the prosecutor of the case. There's a prosecutor in the court. There is a judge advocate. In this particular general court martial, he's a master's law holder. I had some of the judges really pouring water on the qualification of some of the members of the general court martial. But we have the judge advocate who holds an LLM.
That's true, General. But when I look, when the judgment was being passed, the Chief Justice was clear. The judge advocate is similar to an assessor. He is not liable for any conviction that happens here. He's no different from a civil court that has 3 assessors that are not liable to the judgment of the judicial officer.
Now again, that is the, I think, lack of information of how the court operates. The military way is that a panel or a team is held responsible. A court martial, as a team, you will not hold the chairman singularly responsible for a decision of the court martial. No.
I see you itching.
Yes. The court, when they...
Where is he itching?
On that very point.
On that point.
The court headed by the chairman in this case, and the panel he sits with is the court.
Yeah.
The prosecutor, whereas it's part of the whole court framework, but when we're in court, we are supposed to be, me, a defense lawyer, I'm supposed to be at par with the prosecutor.
Correct.
He's sending his case, I'm defending my client.
Correct.
The judge advocate advises court on legal matters. Court is not bound by his advice. It can reject it, it can adopt it with modifications. So that's the correction I wanted to make. That the court which makes the final decision, the chair and his panel, they are not bound by the judge advocate's advice, who is the technical person.
Thank you, John.
Well, I will need to cross-check with the General Tukachunguru to find out whether he has, what he's telling me is what obtains, since I have not been in that general court martial, but I've been through our court system myself as an accused. So, yes, I've faced our judicial system as an accused. So I know what I'm talking about.
But not the court martial, have you?
But the court martial is the superior court, the courts I went through. All right. So the question of Jamil Mukulu. Jamil Mukulu is in the international division of the court, of the High Court,
which is the civilians court.
Yes, but international division. Why? Jamil Mukulu has blood of foreigners on his hands. Okay. So the jurisdiction of Uganda on Jamil Mukulu wouldn't be sufficient to cater for those cases where foreigners were killed by his forces. The same thing with Thomas Koyero, who is being charged in the same court. So it's not ordinary.
So the people that murdered Kawesi, the people that attempted to murder General Katumba, why not in the court martial?
Those are Ugandans. So it's a Ugandan matter.
Illegal arms with them?
It's a Ugandan matter. That's what I'm telling you.
Let me come to Brandon. Brandon, the thing, these proposals that you have made, where do they leave civilian courts, but also where do they leave the mandate of the DPP?
Well, the DPP herself also, after the Supreme Court ruling, everyone had that question. But there was a format where a team of people was appointed and carried out the process. So I think following the recommendation, if you would go deeper, such provision would be made. And I think since there is a saying of subordinate, it will be subordinate to the civilian court. This is the time that everything should be put in line. We may not want to speculate where what will be left where and how, but I think when we give it a process, and if there is anything that will require probably new amendments or legislation as it will be required, we shall be there to support as Parliament. So where it lives for now, I may not have the answer, but the strength from the ruling of the Supreme Court, I think we shall be heading to something better that would also quash the feeling within the political-minded people were actually up to now insinuating that this court, this provision, is only going to cater for the political crime perspectives, that I would say, because it's in the mind of people where it's very, very much scary. It's ill to this person, it's targeted for this place, for this period of time, which I don't think would be nice.
Would you put any doubt to that skepticism, how the timing of the proposals are coming a few months to nominations for both members of Parliament and the presidency?
No, 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 no. I don't want to think that way. The power of positive thinking tells me if a matter comes, it has to be dealt by then and then. Since it's not been there, the Supreme Court, the judgment, when the Honorable Kavezeruka went to court, it's been years and years. Can we say this was timely that the Supreme Court gives judgment?
May I ask? Sorry to cut you short.
No, please.
You mean we should stop business because the elections are around the corner?
No, no, no. It's a question of concern and skepticism from the public.
So you just rest your fear, have hope and strength to look forward that this will be better for this country.
So when you look at section 119, 1 H and G there, from the UPDF Act, which was annulled by the Supreme Court and seemingly coming back in a different way, and just taking you back to the Public Order Management Act that was coined from the Police Act, and then sections of it annulled, doesn't that cause concerns for you as a member of Parliament?
My role is still to make sure, I mean, that's why we have amendments, and that's why we can have good legislation. And let me just assure you to put your fears. When we reach that process, we shall have legal minds. We shall invite the lady there, we shall invite the Honorable Musisia, so that we can put, because these are experts that can help us to guide. And Parliament is actually a public place. So,
and I'm going to come to you, Honorable Mar. Someone asked a question here and said, where is the place for public consultation, as in consultation of the citizens? Where is that place? Because with it coming from caucus, we expect it on the floor of Parliament anytime. So where is the place where the public has their input?
We still have committee. We shall have our Committee of Defense and Internal Affairs, and the chair will call upon people, they will come, the legal mind and the rest of the people, so that's a public participation. And then the other thing also, you call your member of Parliament, especially the members of Parliament from the opposition. Because normally when we go close to close, they run away and they address the media. And where there's a very great gift, if you want to fight for something you want, you have to, in Parliament, my senior legislator here knows, and Omara knows, we have a committee stage that is chaired by the Speaker. So you call your member of Parliament and insist on that. Instead of going to the media and say this NRM, this and this and this, we shall be talking that months and months, and that's where it will end.
So when Timothy invites them, we don't want them to talk about you.
They should talk about us where they are gazetted to talk.
You know, he has reminded me, there was something we were discussing, handling in the 10th Parliament, and one particular member of Parliament from the opposition would look up to see where the camera is facing. When the camera is facing him, he would be and when the camera moves away, the man would come down. I took note and I had to observe this honorable member.
Yes.
So this playing to the gallery is not something new Brandon is inventing. It's actually happening.
But you also know some members of Brandon's caucus, when they attend, they even add extra chairs in parliament.
We have free. We have
seats on Brandon's side are not enough.
we have free sitting in parliament now. We enjoy, but sometimes when the other side is empty, we don't want the fourth estate thing. Actually, we protect your members of parliament because they have not put it in.
Absolutely.
Yeah.
Honorable Mara,
Yes.
when you look at the decree that came from the Supreme Court, 7 orders there. The first 4 were really on annulling those sections. The second one was seizing the trial of civilians, but also soldiers defined in the penal code, crimes like that. And you also look at these proposals from the NRM caucus.
Yeah.
Doesn't this leave us at a stalemate, especially with Article 92 that you have mentioned?
Thank you very much. I think, let me say this, that as Parliament, sometimes we make mistakes. We legislate and make laws, and when the population feel that particular act of Parliament offends the Constitution, they go to court, which has happened in this particular case. So we are going to be a little more careful because the government position is very clear that the government of Uganda is going to abide by the judgment of the Supreme Court, and the implementation of that is already taking place. Now, and the recommendation and the orders of courts were very clear in terms of how we need to, as we already mentioned, to making sure that the court martial is independent and can provide justice to members of UPDF. So that we are going to do it, put it in law, making sure that we democratize it, we provide that independence, so that even when a soldier comes before the court martial, they know they're going to have justice. So that is already something we are going to do. The second one, window, which we are also providing in the recommendation, is to making sure that the court martial is subordinate to the civilian courts. So, which means a soldier who is not happy with the the judgment of the court martial can appeal to a court of appeal and to the Supreme Court. So, which means that the court of judicature will still have the supremacy over the court martial. The third one now, which now borders on national security, on the issues of the civilians getting involved with elements of security forces on their own, acquiring guns illegally and so forth. That is still a very gray area of discussion. And Article 92 is a very poignant article. And we are going to see if we bring in the civilian component into the act which is going to be amended. If somebody goes to court again in future and it's nullified, won't it look bad on us? So we are going to have a very robust discussion around it, and we will have all the legal minds coming together. And then also the other thing is that we as members of parliament, we said, if you're going back to your constituency, go and do rallies around it, get the input from the population, so that even when you come back, you really have what the population is thinking in terms of, for us who are in Otuke bordering Karamoja with the Karachunas coming across. I don't know whether the Otuke people want to support an amendment like that, but we need to make sure that everything that we do is, number one, we respect the judgment of court, and number two, we make sure that it does not offend the constitution of our country, but also it must give us a protection in terms of what the constitution provides, especially the presidency. You just imagine you need to provide security for the people of Uganda, and then you have the constitution, which sometimes, again, you want to do a quick job. People say, now, Mr. President, somebody was shot dead and the matter has taken, in fact, during the caucus, about 3 people came up to say, I was armed by somebody who had a gun, did this and that. The matter was taken to the police, didn't even go to civilian court. and so forth. So there are Ugandans who feel void in terms of justice, even through our normal court system. But that is, in a nutshell, not an excuse to say our judicial system does not work. In fact, when we were discussing the NDP4, we looked at the budget, especially what was provided for the judiciary, and we said, if we don't give them enough money, there's no way they're going to deal with the backlog. So, as much as we said we want quick trial in the general court martial, we must work hard to unlock the blockage which is in our judicial system. Not even in the judicial system alone, even in our public service, the inefficiencies that we have there. For example, if the Chief Justice, for example, would give every justice or every judge to make sure that they come up with judgments per month or per year, you must be able to deliver so many judgments. Otherwise, these guys keep on postponing, and the civilians are not getting justice. So that is why you find others will actually say, I would rather have these matters, especially relating to guns, go quickly and be handled by the court martial. So I think is, how do we get justice as citizens from our judicial system and also from the court martial? And in this particular case, it looks like the thinking is on matters to do with weaponry, where civilians get involved, and we know we have the, our legal systems, our courts of judicature having the rights to adjudicate over matters civil and criminal. That one is already a given, but the question is, how quick can we go with this thing? So what people want to cure is fast-tracking justice and prosecution. Whether that is the solution or not is something that we'll continue to debate.
Before I get to Council Musisi, we have nominations come September of this year, right?
Yeah.
And October for the presidency there.
Yeah.
Isn't it suspect that such proposals come in such a season?
Yeah.
And isn't this weaponizing an amendment like this for political gain? And who benefits from this?
There is a fear in some of the quarters, in the political quarters, that this can be used, for example, if they say a civilian holding a gun will be charged in a court martial. And they said somebody can use rogue elements within security to plant a gun or to plant weapons at the homes of their political opponents, so that they're arrested and taken to court martial while you have a free ride. That is something which is in the mind of the people. But how frequently has it happened? Maybe we need to ask that question. We've had elections here. Have the state or state elements planted guns at somebody's home? So it's a balancing thing. Otherwise, we'll now be legislating in what? What do we call it? In anticipation. Don't make this law because we anticipate something will happen, which is not part of our parliamentary rules and procedures. Yes.
Somebody had the disagreement to the husband, and she called me and said, this man has an illegal gun. Her husband.
Yes.
And like a civilized officer, I didn't rush to arrest the person. And actually investigating, we discovered the man, yes, was armed, but legally.
Yes.
And so what I'm saying, therefore, that we are above those suspicions that we can be easily used. And you see, I get back to the same issue. Why are we suspecting the incumbent president to be the beneficiary of this legislation? Are we not falling prey to what happened in the CA? Because if you examine some of the provisions in the Constitution,
yes,
they were legislating for the present, not for the future.
But General, you know it happened to Honorable Chagulanyi, where allegations were made with weapons found with him.
And
you also know it happened to Colonel Dr. Kizabesi. So the suspicion is substance. There is substance to this suspicion. It's not just for.
Were those individuals actually convicted by the court?
When the allegations taken to court?
They were not.
When
they were not.
When
they
were,
but
exactly.
Were those people convicted by the court?
That's the question, because The political
answer
scene
me,
is here.
because if the court goes by orders, why didn't it convict them?
No, I cannot.
Yes,
Yes.
Council.
Let me first try to answer Honorable Mara, who says that we should not legislate by anticipation. Actually, whereas we shouldn't legislate by anticipation, but many times, actually, sometimes you can't legislate by anticipation because, for instance, if you bring up a law to forbid crime, many times the crime hasn't happened. Your parliament, I was going to say you people, but your parliament passed the Computer Misuse Amendment Act. You know, it was being passed. The presiding authority said, and you people, you are the ones, your opponents are going to use it against you. So this law is going to protect you, and you passed it. Draconian as it is. So I've actually seen a number of cases of trumped up charges. And yes, you ask me, are there trumped up charges in civilian courts? Yes, they may be. But because there are different thresholds here, General College asked who is the complainant. The original Kabas Guruka in the Constitutional Court, the main reason why they held that was unconstitutional was that the army is the one trying you. Unlike here where you have a different authority altogether called the DPP. The army, the prosecutor is the army. And the army is the one charging you. So that's the same institution, part of the executive. And then sometimes in some cases, or actually in the majority of cases, the army gives you a counsel.
Yes, if you can't afford one.
If you can't afford one.
Yes, we offer you one.
So the complainant is the same person charging.
But even the civil court's the same, isn't it? If you can't afford one, they can't appoint a judge. I mean,
they don't appoint part of them. And the DPP is not part of judiciary. The DPP is totally independent. In fact, judiciary can seek, is totally independent. Secondly, I wanted to give you examples of there have been cases of actually outright trumped up charges. Leave alone, and General College is saying that were they convicted, sometimes it comes at a big cost. In 2020, the NUP presidential candidate was in Kalangala. His entire team was arrested on 30th December 2020, and they were in detention. And after applying for bail successfully for over 100 of them in Masaka, 48 of them were whisked away and brought to court martial. And the charge was that on 3rd January 2021, they were found in possession of 4 bullets in Makerere. Never mind that all the 48 were in state custody. Actually, some of them were in the custody of the army in Masaka at the time when the alleged offense was supposed to have happened. Yes, they were not convicted, but they spent 6 months in custody over such a frivolous charge. Of course, Timothy talked about the issue of the guns which were displayed and were alleged from the rooms. So the issue is there is a high likelihood. And of course, there's been a history even before NUP. You remember in 2005-06, when Dr. Besigye and his PRA, as they were facing a parallel trial in the High Court, they were facing a trial before. And I remember it was stopped by court. And I remember General Tumwine, God rest him in peace, saying, I don't respect court orders. Because at first, the order came halting that trial in 2006. And eventually, I think the common sense for them along the way. But the issue is, and the question I would want to ask, possibly for General Kolaiji, what harm would be suffered if these civilians are tried in the civilian courts? What harm would be suffered? Are they saying that these courts are not competent to hear a case of a person found with a pistol or with 1 bullet? These cases, these courts which you've said can handle Jamil Mukulu, cannot handle someone found with a T-shirt?
Can I answer?
Sure.
No, T-shirt is not my interest. Following from the way I started my submission at the very beginning, the person with this social contract with the population has an option of utilizing the tools given to him by the Constitution.
Within the law.
Within the law, of course, to help him execute his. And the two, which ones come easier for him than these who have sworn
allegiance to him,
allegiance to the country, surrendered their lives for the good of the country, so their loyalty is not even questionable, or their commitment to execute their work is not doubtable. These are men and women who every night stay in the cold so that Council Musisi is alive and safe. So you can trust them to expedite justice in the right way. But first, as the council was talking of speed the trial, which I'm yet to see in my lifetime in this country, in the civilian courts.
Actually, I've given you examples, and of course, it's also wrong to say, and General College used the statement, and I quoted it verbatim here, that how long will you take he was talking about the Karachunas, that how long would they take to have a conviction
for the five?
Now, when you are going to try people,
I didn't say tag to secure a conviction.
Yes,
I didn't say tag.
No,
you know the word tag has a different meaning.
No. No one has said tag. I'm using your words. And my point is, when you are going to for a trial, the intention is justice. If these people are acquitted as a result of justice, so be it. But even by the mere fact that the intention for you is to convict them, it already shows a biased mind. There was a soldier who shot someone in Luzira, I think about a couple of years ago, about 6 years ago.
Yeah,
from
Metropolis.
Actually more than I think the gentleman was coming. He was coming from Somalia.
Yeah. And
the field court martial was held in Luzira.
Yes.
And they were saying, please come and see how we are going to convict this man before you. And this was a man who was going to face some bit of a trial. So the issue is, it's akin to the story of the Bushwa story of Waraji, and where Jim was advised that it's alcohol which led this soldier to kill.
You imagine that kind
you can imagine these are the lawyers.
Those are lawyers for you.
Yes.
So the issue is, it's not taking these Karachunas through some bit of a process. The issue for them that our constitutional dispensation says anyone, irrespective of what is charged with, should have a fair trial. So if they are acquitted, if they are convicted, so be it. So it's not about fast. And like I've told you, there are many cases which have people who are on remand.
Can I give information, which is current actually? Today, I was watching Al Jazeera. The police and the army in El Salvador, okay, have been given powers to arrest and detain without trial criminals that have been terrorizing the civilians. And so the media carried out a survey. 90% of people who were asked said, grab them. What am I talking about?
General, on that same note, El Salvador decided to do that because of the gangs that were in the country. They even created a specific jail for that. But you have cut me short
before I end my point. I'm saying the objective reality determines how you do your governance. It's not about the ideal. The objective conditions matter.
Because what you're giving as an example is that the ideal that is here. Because that is for their circumstances.
Well, the objective reality that is here, that we are surrounded by conflicts.
General, let's talk about our country. Because
yes, I'm talking about our country.
You're not going to arrest people out of the country.
No, what I'm saying.
General, I'll come back to you. Counsel, let me come to you. What does this mean for our civilian courts? Especially in hindsight with what the Chief Justice said. He talked about him as a Chief Justice, he can't tell the difference between a kidney and a liver. Even if you sent him to a front line. What does this mean? Isn't this an indictment to our civilian courts and the processes, especially as they happen?
No, I don't think it's an indictment. The independence of courts has always been under test by different reasons. And of course, courts can only stop at giving pronouncements. And these pronouncements are supposed to be executed by other people. In this case, Parliament. And just in case, Honorable Brandon was saying that, you know, we shall involve the public and what. If they pass something which we think is unconstitutional, still the courts will come in to say this is unconstitutional. Because even in a case, there's some court orders which are disobeyed at will by different agencies. So for me, I don't think it's an indictment on the courts. The courts have done their part. More or less, the highest court in the land has made pronouncements. It's now up to the agencies responsible for executing those. In this case, it's Parliament. and if they do anything out of line, still the courts can pronounce, but it's all up to the different agencies to implement.
Helen,
I
yes.
just want to maybe clarification, because now he's a legal man. If you go to some of these courts, you find that a judge has not appeared today. People are invited to court, the judge is not. And then the court clerk, I don't know, gives you another date. The judge has trouble here. The judge is on study leave. The judge is this.
Paternity leave.
So we need, you see, we need to deal frontally with the inefficiency in our judicial system, in our civil service systems, because that leads to the delays of justice to many of the people that go to court to get justice. And so the Chief Justice and also the principal judge, they need to just sit down and say, how can we be more efficient? The judicial officers attending to court matters, why is it that they don't appear in many of the cases? And the same thing, if you go to, for example, a classroom, you find these teachers are in the classroom every day. In the morning.
Just a quick,
that is where the problem is.
just a quick rejoinder in that.
The
Before you
inefficiency.
respond,
Yes.
Honorable Chintu has something.
Yeah, I just wanted to supplement on what Honorable Omara says. It has reminded me. I've been a victim in court, but that was the electoral petition. But when you go to appeal, these men and women in those courts, and even the judicial officers, they will tell you, with appeal, that one you'll wait. That will take even 7 years. It can go 5 years. And yet these people there, they have piles and piles. A new person will come and the other one will come and they will not hear. So the efficiency, and now, I don't know how to translate this in English directly, but I will say it in Uganda these days. They say Masavo Galia Gocha. Now, if we have such serious crimes that need urgent attention, these are masavos that should be eaten.
That's hitting the nail on the head.
Yeah.
When this, I mean, it is his sword.
In fact, as lawyers, we've been very loud on judicial accountability. All those things are there. There's backlog. However, it's not unique to courts, neither is it unique to civilian courts. And yes, I know the judicial can do better in so many fronts. Yeah. But as a person who has litigated in civilian courts and the court martial, I can tell you that possibly there are more delays in the court martials. General College knows, for instance, that the current status before 31st January, for instance, the general court martial, for such a long time, not even this current one alone, only operates on 2 days, at most 3. You're talking about...
It's actually operates 3 days.
Under General Gucci, it would operate 2 days, actually. The 3 came under General Freeman. Under General Gucci, it would operate Monday and Tuesday. Now, sometimes they have a list of 10 cases for a day, and they could hear 3. There was a time, I don't want to mention names, but not the current chairman, one of the former chairmen, would come at midday, and lawyers would be there. Another one would come at 5. He has since died. He would come at 5. One of the lawyers who was they were representing General Kazini then, and Justice Madrama, Justice of Supreme Court, was a lawyer then. They would come and doze at those benches from 9. Imagine waiting from 9, and the chairman would come in at 4.
Okay.
So
allow me bring in Helen. Helen, someone mentioned arrest, investigation, police, DPP, and there's a due process that happens there. Where are the checks and balances in these proposals, especially to create the fairness, to create the impartiality, to create the independence there? And how can they be created?
Yes. First of all, for clarity purposes, I would say that the DPP in this case, we all understand that under the Constitution, their powers are limited to civilian courts. So the question of bringing them into the court martials may not, if we cannot criticize their the fact that they have not been active in these processes before the court martial, because they're working within their constitutional mandate, which is limited to the civil courts. However, that notwithstanding, we still have an issue where the last time we were here, we discussed the proposals that the Attorney General had made, and he had said that he had written to a lot of stakeholders, including the Office of the DPP, to fast-track the process of moving the files from the court-martial to the civilian courts. And it's been over 2 weeks now, but we haven't had feedback, be it public or private, as to how far this process has moved. And yet we already have a court order that can be enforced, and at the same time that is still being taken under consideration as to how to effectively have the longevity. So on the role of the DPP in these proceedings, I would say that whereas they have the mandate to oversee the the initiation or taking over criminal proceedings in the civil courts, they cannot cross over to the general court martial. So what we can critique or, you know, hope that they have come in to help or assist in this process is what recommendations that the Attorney General had written to them and proposed, that how do they assist, how do we see that these files are effectively moved from this side to the civil courts, which is the proper forum before which they should be presented. That's one. Then on the other side, we can say, I understand that there's an issue of that our courts are inefficient to handle. There's a lot of case backlog. We are seeing that some cases take longer. They've mentioned appeals. But the answer to the inefficiencies in the civil courts is not enforcing unconstitutional actions. So we cannot say that just because we have one wrong on the other side, then we create that other wrong to do away with the entire, you know, the entire confusion that is in the court systems. So what can actually happen is that our legislators have a chance to put in place a system that is not only going to serve the political atmosphere that we have in Uganda right now, but to transcend what is to come.
Posterity.
Yes. So we are looking at a system where we not only look at how do we preserve, they've talked about the security concerns. We've looked at the fact that Uganda is an island of peace in a sea of conflict, yes. But in doing so, we do not do away with the rights of the people that are in this sea of, in this island of peace rather. We still have to keep the aspirations of the people at the forefront of whatever decisions we make. And we see that they have made suggestions that talk to your members of parliament, reach out to them, make phone calls. But I can say that the voice of the people has been heard through the civil society. There's been a lot of talks, there's been a lot of proposals regarding the implementation, and there's been a lot of feedback both on social media, in parliament, on the news. So we know what the general consensus is. So the question is not that we have not heard what the people have said. The question still stands. We have heard what the people have said, but how do we incorporate our personal interests into what the people have said? So, and that still brings us to the point that we should not look at the interests of a smaller group, be it political or whatever other incentive is behind that move. We should look at the general population. In as much as we want to maintain peace in the country, in as much as we want to see to it that there's a system of discipline in the forces, we still have to keep in mind that the people who serve in the forces are still citizens of Uganda, and that the people they protect are still citizens of Uganda. So, and we are also still citizens of Uganda as the legislators, as the enforcers. So we still have to keep a system that does not just serve one arm, does not just serve a particular group, but serves everyone in general. So it still comes back to everyone doing their part and doing it impartially, not just to their interests, not just to what they think should be the position, but for the common good of the people that gave them the mandate to serve.
Thank you. Let me read some feedback. General, I'm going to give you parting shots. Let me read feedback so that I can give the gentleman and lady parting shots. Good evening, Timothy. You need to explain to the viewers the purpose of the court-martial. The army, civilians, this is Ruakaka from Mutukula. Okay, thank you very much. Good evening, Timothy. Thank you for the show. Ugandans are very aware of the situation for how laws are amended, just to fit anti-citizens laws. Does this mean civilian courts shall be abandoned? The rule of law finally collapses in the open. We really need to stop playing dirty politics for our country to develop. Okay? This is Kansime Greens from Chiruhura. He says, the significance of the party caucuses is to create awareness, harmony, direction, and order among party members. Therefore, I commend the NRM for conducting themselves, and also I commend Afande General Kulaije. My question to Afande is, why are the most notorious terrorists not tried in, are tried in civilian courts and not the general court-martial? Thank you very much. Next comes in, good evening, Timothy. Whatever the government is doing is to scare the opposition in 2026 general elections. The ones supporting the amendments in the UPDF court-martial will be found victims tomorrow, suffering the unlawful remand. I am Grace from Kakumiro. Okay. Lastly but not least, Daniel here watching the program from Mbale. Thank you very much for your message. Someone else, Chakala says, I think there's a certain type of civilians targeted by the military court. That's why the government cannot let go of the trial of civilians in the military court. It's targeted political civilians in this manner. And finally, I think the panel, any amendments that offend the Constitution and goes against the Supreme Court ruling is still a nullity. No civilian before the military court, but instead we need better laws. This is a gentleman from Barra says, and is Lawrence, the problem we face is selective application of the law, especially political opponents there. I'll start with Helen, your 2 minutes of parting shots. Council Musisi, Honorable Mara, Honorable Brandon, and finally, General Kulaije.
Thank you, Timothy, and thank you to the panel. It's been a very insightful discussion that we've had this evening. And thank you to the viewers as well, because your interaction and feedback guides the conversation. And as we conclude this conversation, I would say that it is promising that we've had the honorables suggest that there are still conversations around how best to implement the court decision, and that they are alive to what the court decision is. The only concern, however, is that the proposals we've seen so far are avoiding or are not looking at the major focus of the decision, which is the trial of civilians in the military courts, and that moving forward we should have more extensive discussions from the legal minds like you suggested, as well as the people, the general population. We can pick more from what the best amendment would be, not just as, you know, the panelists here, not just as Timothy, but everyone in general. So thank you to everyone who has tuned in, and thank you to the panel.
Council Musisi.
Well, mine is a plea to the legislators, Honorable Mara and Honorable Brandon, my brother. Through a quotation written in a book by Sir Robert Bolt, A Man for All Seasons, so many years ago, 1954, I'm sure General Kulaije read it, where one of the characters said, when you've cut down the last law in the land and the devil turns against you, where will you hide? So the legislators have that in mind, that we are legislating for posterity, not for nope or political opponents or today or tomorrow, because none of us knows what will happen. But let us keep in line with the Constitution, the spirit that was quite enforced by the Supreme Court.
Thank you very much. Honorable Mara.
Yeah, thank you, Timothy. I just want to say this to the country, that our constitutional democracy is actually working. Because as much as the presidency was a bit uncomfortable with the ruling, he has muscle all of us together to obey the ruling of the court. So that is an advancement. In the past, we could have had a coup who said, we can't listen to the courts. I think that is the furtherance of our constitutional democracy. So the constitution is working, it's fragile, we must keep it. Second, the population should know that what is being proposed is basically to make sure that we implement the directives of the court, to make sure that the court-martial, in terms of its structure and its representation, actually there is independence, they can provide justice to members of our security forces, which section the court nullified. The recommendations also make sure that there is an appellant process to a higher court, so it makes the general court-martial subordinate to higher courts. The third one, which is controversial, which is still a proposal, which will come before us, is some of the civilians that get involved in illegal guns and use them violently against citizens, then they might have to go through first the court-martial, and it can go through the appellate process up to even to Supreme Court. So that is something that we are going to discuss. So I don't think there should be any sense of trepidation or fear in the population that this law, when enacted, will be targeting some particular individuals. So it is proposals which actually the Land Attorney General said, no, we still even need to clean it up. So there's a lot of cleaning that will happen, and there will be broader consultations to make sure that we don't repeat the same mistake when, again, the law is enacted and somebody goes to court and the same provision of the law is nullified. So I would want us to remain positive and not to be suspicious of the UPDF Amendment Act, which will come very soon.
Thank you very much.
Thank you.
Honorable Brandon.
Lightly, the Honorable Paul has spoken. I don't want to repeat, because I would share the same sentiments. But I would like to thank you and invite the two councils, my special counsel Helen there, very calm, articulate, and very sensible. So I would welcome you to the committee.
You invite both of them.
Yeah, but you know, you have to. Because Helen has really exhibited, I was following, and it's really a very great sense. And I think with such voices, we are here for the country. We are very patriotic. Have faith, Council, must have faith in the members of Parliament. I have, I invited you yesterday. I've been with you the whole week. I've been inviting you for the public. And Timothy, please come, so that you can digest good information to the public.
Thank you very much. Lastly, General Kulaija.
First of all, I found a bit, I became a bit uncomfortable with some of the statements made by Councillor Helen. The public has spoken through civil society. Yeah. Now, civil society has no mandate to speak on our behalf, because nobody has elected them. These are elected. Two, legislating for a small group. I was uncomfortable with it as well. 370, did you say?
337.
And 37. Out of 500
and 29.
And 29. That's not a small group. And they are elected members of Parliament. I wanted to correct you on that one. As I said, and I want to exploit my seniority in age, never lose sight of your history.
Of the past.
This stability we are enjoying could easily be lost if we play around with it. So legislate, argue cases in court as an advocate, be mindful of where we have come from.
Hey, General, it sounded more of a threat than...
No, I'm only sounding a caution.
Yes.
And as an elder, I should do that. Otherwise, I've betrayed my country and my calling. Lastly, lastly, sir, like this kind of amicable discussion, I would plead with Council Musisi. Let this be the manner of conducting business in our country.
Yeah.
And his perspective is coming in the 12th Parliament.
Well, whatever his plans, but I because he's a sensible man, I have seen him, and I'm appealing to you that sensibility to be spread out. Please positively infect your colleagues with this kind of demeanor in dealing with national matters, because we are dealing with the matters of your children and my grandchildren as well, and the children, our children's children. So we cannot afford, and this goes to everybody who is a political actor at Timothy. Let nobody regard elections as a matter of life and death. Respect each other, respect the laws. The law enforcers will respect you.
Okay.
Timothy, are you going to read out the other prophetic tweet?
We shall. Good evening, Timothy and the panel. I must first acknowledge the necessity of the court-martial in particular circumstances, especially military operations and personnel. However, General Kulaije, in many words, misled the public by not making a distinction between the nature of offenses triable by civilian courts under the penal code and offenses triable by the court-martial, which he also mixed with the people who qualify to be tried by the two different courts. The element of complementarity therefore could apply in specific circumstances like insertion or army rebellion or mass army crime like Karamoja, cross-border arm, and cattle rustling. Julius Nkunda. Okay. Gentlemen and ladies, thank you very much for coming. Thank you for agreeing to come on our invite. The production team, thank you for making today happen, but also the ones that have sent through so many messages. Some we could not read them. We'll end with this quote. Unlike the stomach, the brain does not alert you when it's empty. Good morning.
That's a good.
UBC, inspiring Uganda.
This PDM is to get all of you out of poverty. That's why we said 100 million per parish per year.
The parish development model is designed to eradicate poverty by providing the support necessary for financial independence.
We have seen how 1 million, how much 1 million can do. The whole of Uganda is very rich. So what you call poverty is actually ignorance. We need everybody to come up.
Let us all take advantage of the conducive prevailing atmosphere of political stability, peace and security to ensure that all our people come out of poverty.
And I've told the banks to stop deducting from the 1 million. You must get the 1 million full. The government is the one which will pay the bank charges.
Now the number of stools in this Matoke enterprise are 1,000. They are on 1 acre. And we harvest 17 bunches every day. The money that we get from this Matoke, after selling each bunch at 15,000 shillings, for the whole year, we get 91.9 million shillings. So I want to encourage all the people of Teso also to change the mindset and adopt to new crops which were not traditionally grown here.
We emphasize two words, wealth and jobs. This PDM is to get all of you out of poverty.
This message is brought to you by the Ministry of ICT and National Guidance.
Our program of poverty eradication is a must. We want everybody to be involved.
Through the parish development model, Ugandans are starting small but impactful projects to improve their livelihoods.
When we give 1 million, we know it's not enough to do many things, but it's a starting point.
I'm a PDM beneficiary, a farmer. Your Excellency, I was given 1 million Uganda shillings from Kobil Kawo PDM Circle. Your Excellency, I got